appeal in the matter of Commissioners for His Majesty's Revenue and Customs and GE Financial Investment.
Yes, Ms. McCarthy.
Good morning, my lord, my ladies. I appear with my learned junior, Miss Barbara Belgrano, for HMRC, the appellant, and representing GEFI, the respondents, are Mr. Baker, King's Counsel, and Mr. Brinsmead Stockham, King's Counsel. Please may I just check a couple of things for housekeeping purposes. You should have, in terms of bundles, core, supplementary and authorities. And please can I ask, just so I can give you the right references, would you like tab references and hard copies as we go as well, or are you fine with just page references?
Have we got tabs? Yes, tab references would be helpful, thank you.
Okay. And you should then have 4 skeleton arguments in total. And also, we did email our proposed timetable, which I understood was acceptable to the court.
Indeed.
And then, final thing, I sent yesterday, please, if you don't find it helpful, just ignore it. But all I sent, and there should be 3 hard copies just in front of you. I typed out on page 1 the article for different permutations in some of the different things we'll be looking at. And then page 2, I've done a tracked version. And the way that I've done the tracking is from for example, the Model Convention 2000 to the treaty that we're concerned with. So what changes do you need to make to that older previous version in order to get to the version of the treaty that we're looking at? I just found it helpful to have the wording in front of me, but if you don't, please just put it to one side.
Thank you.
I should say it's not a brief, but equally I don't think anyone spotted any major mistakes with it. May I also ask if the court's had the chance to do the pre-reading of the case?
Yes, you can take it that we have read the FTT and UT decisions and the 4 skeleton arguments. And some of us are familiar with the authorities, others less so.
I'm very grateful for that indication, my lord. So if I can then start then my submissions on issue 1, residence. If I can start with a brief overview, please. Looking at the wording of Article 4.1, so if you want to work from the bundle, then that is authorities, tab 7, PDF 115, alternatively it's the top version that I've just handed up. We're concerned with the meaning of the words in particular by reason of his domicile, residence, citizenship, or any other criterion of a similar nature. The issue obviously concerns the interpretation and then the application of that article. And I'm going to start by going through the background facts, which include the US law on stapling. That should all be common ground. I'll then go through the relevant treaty provisions. I'll then make brief submissions on the aids to interpretation before I move on to the main thrust of my submissions on this issue. And I'm going to split them down into 2 separate points. So first one is the pure interpretation. Second one, if we are right, how then does that apply to share stapling? So the way that I put it is to say that, that there are 2 questions. First, what is the meaning of Article 4.1? As I mentioned, that's the pure question of interpretation. We say the words, or any other criterion of a similar nature, is a reference to a criterion with some formal, legal, or territorial connection, or link, or tie, call it what you will, to the contracting state in question that is similar to the connection that exists with domicile, etc. And as we understand, GEFI's position in contrast is that all that is required is a contracting state imposes liability to full taxation, by which I mean liability on worldwide income and gains, not merely income and gains with a source in the contracting state concerned.
Yeah, just pausing there, Ms McCarthy, as I understand the taxpayer skeleton, they do have an alternative or fallback from what they pose, a slight fallback from that. As I understand it, the primary position is that full taxation is enough. But they express a fallback, and are you going to comment on that? I mean, I think the fallback is that the connections created by stapling on the facts of the case is adequate. I don't think there's a respondent's notice, but they put that alternative.
Yes, so that's basically the second question. So I see question number one as being a pure matter of statutory interpretation.
Right.
And we say we accept that worldwide taxation is necessary, but we also say you need a relevant local connection. And if I can just pause there for a matter of...
Sorry, this is, yes, so you're on the pure interpretation point.
Exactly. And so just to sort of expand on what I've said, because the way we see it is we see, my lady, the argument you've expressed as then being a matter of application, which is the second step.
I'm with you, thank you.
Sorry, I was worried I'd missed a nuance point of interpretation. Thank you. So I've used the terms formal, legal or territorial connection. I'm going to just abbreviate it for ease as relevant local connection, so we understand what we're talking about. It's a local connection other than purely being subject to worldwide tax. And the reason I've used the three words formal, legal or territorial is we'll see in particular in the academic texts as we go, some of the authors in the academic texts describe certain types of connection in different ways. So for example, we'll see that Vogel describes something like residence or place of management, which requires some sort of physical presence as being a territorial connection. In contrast, they describe something like incorporation, be incorporated in a country and have no physical presence, as being a formal or legal connection. Now, our article obviously contains a mix of both the territorial and the formal legal. So for our purposes, I'm simply going to call it a relevant local connection.
Well, I appreciate why you make the distinction you do, but one could regard place of incorporation as a territorial connection as well.
One could, and for our purposes, I don't need to be right about the difference. All I'm simply seeking to do, because the Upper Tribunal placed an emphasis on the difference between incorporation, is I'm simply seeking to say that there may be different ways of describing the links. For our purposes, all I'm concerned with is establishing that there needs to be some relevant local connection, and as well as worldwide taxation arising as a result of that connection. And my lord, what we'll see actually is that certainly from the UK's perspective, the UK considers incorporation to be akin to domicile, and I'll get onto that in due course. So that's the first question. I'm going to structure my submissions on that as follows. So text in the light of the object and purpose, then moving on to the OECD Model Convention commentary, then we'll look at some of the foreign court judgments, and I'll finish with the academic texts. Now, if we're wrong on the question of interpretation, we all agree that under US tax law, GEFI is subject to worldwide taxation, so that's agreed, if we're wrong on interpretation. If we're right on interpretation, then we go on to the second part, which I would term application, and that is whether stapling is, from a UK law perspective, a criterion of a similar nature to domicile, etc. And we say it's not, because the relevant local connection with the US is missing, and the first tier tribunal's evaluation, factual evaluation on that matter shouldn't be disturbed. If I may, what I'm intending to do is address the main points against us in the Upper Tribunal's decision as I go, and you'll have seen in our skeleton argument that we address pretty much paragraph by paragraph the Upper Tribunal's decision in each of the places. So I'll take that as read, and I adopt all the submissions in our skeleton, and what I don't therefore intend to do is a paragraph by paragraph analysis of the UT's decision in the end, because that will have been done either orally in respect of the key paragraphs or already in writing in the skeleton. So moving on then, so far as the corporate structure and the background facts are concerned, if I may just summarise this, and you'll find this in the first tier tribunal's decision, which is core bundle tab 12, page 188 and 189. And it's their paragraph 4. I don't think any of this is contested. GEFI itself is UK incorporated. It's a UK tax resident. It's owned by another, or at the relevant time, it was owned by another UK incorporated and tax resident company called GEFI. GEFI Inc. was also owned by GEFI. GEFI is a 99% limited partner in the limited partnership. GEFI Inc. is general partner with 1%. The LP is tax transparent. It's a Delaware limited partnership. But the position of a Delaware limited partnership, and this is relevant in relation to business, but I'll just make the point now, is that that a Delaware limited partnership need not be carrying on a business. So that's an important point to bear in mind when we get onto the second issue in due course. The GE corporate group is ultimately US owned. Now, moving on then, a share staple is nothing more elaborate than than one amendment to each company's corporate documents, which provide, in our case, that US dollar shares of both companies need to be transferred together.
I assume the US dollar shares were the vast, it's not very clear, but I assume they were the vast majority of the shares in GEFI.
Exactly.
We're not told the issued capital.
I'm sorry.
We weren't told the issued capital.
No, and actually I ended up having some discussions to look that up. But my lady, you're absolutely right. It's not in any of the decisions. The US dollar shares were the vast majority of the issued capital at the end. And so we're not taking any sort of point on the balance between pound shares and dollar shares. So if I can first go to the GEFI Inc. Certificate of Amendment, so that is in the supplementary bundle, please. Tab 13, PDF page 315.
415.
351. These are quoted in the decisions, but I'll just show you the documents so you've seen it in the documents. And in the middle of the page, so halfway down that first paragraph, no shares of common stock of the corporation may be transferred to any person unless the transferee ... simultaneously receives all shares of common stock of the corporation and to all of the then outstanding ordinary dollar shares in GEFI. And then behind tab 15, still in the supplementary bundle, page 370, you'll see this is the Memorandum of Association of GEFI, as adopted by a special resolution in 27th of June 2003. Page 377, clause 3.1 sets out the authorised share capital. And in due course, the vast majority of the US dollar shares were issued, even though it's not in the decisions below. And if I could ask you please then just to go to, on page 379, the relevant clause is 8.3a. And if I could ask you just to read that, please. So I'll come back to this later when I make my submissions on application, but one of the arguments that GEFI makes on connection to the US, and the Upper Tribunal accepted in effect, is that it argued GEFI is stable to a US corporation and there was significance in that. But as we've just seen, the US dollar shares are stapled to each other, and if I can put it this way, GEFI is no more connected to the US than GEFI Inc. is connected to the UK in that respect, we would say. So if a purchaser wants GEFI Inc. shares, then the GEFI USD shares are tagged along with that. If a purchaser wants GEFI US dollar shares, then the Inc. shares attached to them. And I'll revisit that in due course. I've made the point that the staple affects only the US dollar shares, not the GBP shares, but we're not.
I mean, the stapling is an aspect of the control of the company or the ownership of the company. And the related point relied on
Yes.
is US control, or US owned control of GEFI, which obviously, because of the staple, would correspond to control of GEFI Inc. So the stapling is another aspect, is really simply an aspect of ownership or control. Isn't it?
So I'll come back to the submissions on application in due course, but we say that well, we say a couple of points. The first point is that the immediate owner is itself a UK incorporated and tax resident company, GEFI.
Yes.
So point number one, and point number two is how far up the chain, therefore, is it reasonable to look for the purposes of interpreting whether or not you've got a criterion of a similar nature.
Yes. But it's also never been suggested, has it, that mere control or ownership by someone based in one territory means that everything that is owned should also be regarded as
And so, yes,
associated with that territory.
exactly. And so, my lady, that was the point that I was going to go on to. What we'll see in due course. Assume for the moment you're right, and a relevant local connection is required. Then we'll see, by the time I've finished going through the treaty, going through the cases, going through the academic text, the one thing that is universal, as you quite rightly point out, mere ownership without more is never enough, we say, to drag a country away, a company here away from the UK into the US. So forget stapling. Stapling, in fact, is a bit of an irrelevant complication. Just assume you've got a subsidiary. US incorporated tax resident company, UK subsidiary. Assume for the moment that the UK subsidiary is incorporated in the UK, is managed and controlled in the UK, everything about it is UK based, apart from the ownership. There's no treaty that would recognise that mere ownership alone as being sufficient for tax resident. And if I may make one additional point, if my learned friend is right in his submissions that all that matters is tax residence, the consequence of that, my learned friend calls our blue logo example ridiculous, but the consequence of that is the US tomorrow could come up with a law that says, well, all foreign subsidiaries of US holding companies are taxed on their worldwide income. And that would essentially drag all UK subsidiaries over to be a US tax resident as well, and the treaty would then you'd have to work out what the position is as a matter of dual residence, and that makes no sense. What my learned friend and the Upper Tribunal would say in response to that is, oh, well, hang on a second. A, that would be a change, and B, countries, contracting states are supposed to act in good faith, to which we say, well, if everybody has understood that all that is required is worldwide liability to tax under Article 4, where's the bad faith? Why is it bad faith to change your laws in a way that everyone understands you're free to do and impact residents?
I mean, there's another point also which struck me, that the question of good or bad faith must have something to do with the provisions of the treaty.
Yes.
And one presumably has to consider whether the US might take action that hasn't, at least as its prime consideration, any treaty aspect to it. I mean, the US might, very well publicised examples of US-owned corporations that are not, that make vast earnings outside the US. The US might regard it as having rather good reasons, as it no doubt regarded it had for the staple stock provision for extending the scope of tax. And other jurisdictions do that in different forms.
Exactly, and they should be absolutely free to do that as a matter of their own sovereign powers, without having to go back and renegotiate every treaty with all of the contracting states every single time they make a change. But everyone is safe to assume that if their relevant change doesn't relate to a relevant local connection, then the contracting partners can rest assured that it's not treaty resident. And that their treaty hasn't been disrupted in any way. So we've called it in our skeleton a bootstraps argument. I mean, it's, as far as we're concerned, it assumes that which it seeks to prove. You can only be accused of having acted in bad faith if you've done something that's contrary to the terms of the treaty. If my learned friend is right, and the terms of Article 4.1, the worldwide taxation only is all that you require, well, where's the bad faith? And if I can equally deal with the other, what we've rightly or wrongly called the bootstraps argument, the point every country is presumed to know the other's laws. Oh, absolutely. But if we, knowing about stapling, recognise that it's not a criterion of a similar nature, well, we in the UK had no problem entering into Article 4.1, knowing about stapling. Because we in the UK were satisfied at the time, hypothetically, that that wouldn't have meant that stapled entities are also now suddenly dual resident. And we in the UK are happy with Article 24, where if there's a clash in relation to dual corporate residence, we see taxing rights because we just don't see stapling as getting through the gateway in Article 4.1 in the first place. So all of those points, which I think the Upper Tribunal found attractive, actually we say are self-serving. If I could please go to the relevant US law, I've sort of encapsulated some of the points that I want to make later already in that, so I'll try not to duplicate as I come back to them. But if I could ask you please just to go to the US law on stapling, which is Authorities tab 57. So Authorities tab 57, and in the PDF it's 1414.
You might need to give volume numbers for authorities, I'm afraid.
I'm going to say 3 at the same time as looking behind them.
If it's 57, it's 4.
Okay, I'm sorry. We that's the problem I think with I'm now working off soft copies. Is that I had omitted to find that out? Sorry. So
Don't worry, it's us dinosaurs who have to cope.
I'm on soft copy too.
So you don't need to worry that it's
So I'm happy with
So am I. I might resort to hard copy on something.
Sure. So page 1414 is the definitions section. So corporation, 3 corporation is as you'd expect. Now 4 domestic. The term domestic, when applied to a corporation or partnership, means created or organised in the United States or under the law of the United States or any state. And pausing there, that is something that we in the UK might recognise as being similar to incorporation. Now, I'd like just to look very carefully then at how foreign is defined. The term foreign, when applied to a corporation, means a corporation which is not domestic. So there's no chance of being both. Sounds silly, but there's no chance of being both or some sort of hybrid. You're either domestic or you're foreign. They're mutually exclusive. If I could ask you then, please, just to go up a couple of pages to 1411, tax imposed, section 11. Corporations in general under A tax is hereby imposed for every taxable year on the taxable income of every corporation. So that is the essentially tax on worldwide income provision. But then if we look at D, foreign corporations, in the case of a foreign corporation, the taxes imposed by subsection A and section 55, we don't have 55, shall apply only as provided by section 882. And in effect, we all agree that in relation to foreign corporations, it's source only. Now, the rules in relation to stapling are then page 1412. And I'd like just to pay particular attention to A1 for the moment, please. Except as otherwise provided by regulations. So for the purposes of this title, i.e. not for every purpose, just for the purpose of, you can see at the top, Title 26 Inland Revenue Code. If a domestic corporation and a foreign corporation are stapled entities, the foreign corporation shall be treated as a domestic corporation. Now, pausing now, I want to make 2 points on the deeming provision. The first point is, it's a condition of the deeming provision that you have a foreign corporation. And the second point, the foreign corporation shall be treated as a domestic corporation. So the foreign corporation shall be treated as the very thing it isn't. And I emphasise that because, as we'll see from the case of Fowler in the Supreme Court, there's potentially a distinction as to how a court or how a contracting estate might approach a deeming provision. So you could have a deeming provision that is basically for ease of reference. So if someone looks a bit like they have personal links to the UK, we're going to deem them to be resident. On the other hand, you could have a deeming provision which is like this deeming provision. We're going to deem something, a foreign corporation, to be the very thing that it's not. And when we look at Fowler, in effect the Supreme Court in Fowler says, when you're applying a treaty, this is a paraphrase and it's more sophisticated than that, but disregard that sort of deeming for the purposes of applying.
Which sort of dealing? The black and white sort of dealing?
The black and white, yes. You deem black to be white. The treaty isn't concerned with that state of affairs. The treaty is concerned with the real state of affairs. And in Fowler, which we'll see, the contrast was between somebody that was, as a matter of fact, employed, being treated to be self-employed for income tax purposes. That's a paraphrase, but we'll come onto it. And of course, when...
So can I put that the other way around? Because the message I take from Fowler is that you only ever take a deeming provision as far as it needs to go. Again, it's a bit of a rough paraphrase, but we can live with that. So could you put it the other way around and say, if you have a foreign law, so 269B, that has a deeming provision in it, you have to ask yourself, what's the purpose of that? And you could say to yourself, that's just for US tax purposes. It doesn't go as far as carrying into the treaty, because the treaty is concerned with real world events rather than deemed US events?
Yes, yeah. At a very high level, that's how I would put it. Can I maybe give another example? And I don't want to go too far into sort of making up laws that aren't real, but assume for argument's sake, assume for argument's sake there was a deeming provision that said, well, even though your company may not be organised in the United States or under the law of the United States, if it has a place of management in the United States, we will treat it as domestic.
Mm-hmm.
We would say that that is something quite different to the black versus white type deeming provision, especially for treaty purposes, because as far as the treaty is concerned, what I've just described, place of management, is something that is a relevant local connection. And so you would say, well, you'll deem state of affairs. Ultimately, you still have the relevant local connection, and that's how your deeming operates. So we're not concerned whether it's deemed or not deemed, we're really concerned with the state of affairs underlying that. Contrast this situation, we would say the fact that the US law has treated it as a domestic corporation is a complete irrelevance, because ultimately you don't have a corporation that is created or organised in the US or has a place of management in the US. It's a pure tax fiction. And there's a paragraph in Fowler that quite neatly sets out the different ways in which deeming provisions might operate.
Good, thank you. We'll go there in due
And
course.
we will go there in due course,
Yeah,
yes.
thank you.
Now, if you look further, if I can ask you to look further, please, at the definitions. 1412 still. Entity means any corporation. Stapled entities, any group of two or more, if more than 50% in value of the beneficial owner, consist of stapled interests. Stapled interests is defined then over the page 1413, and we've already seen how that operates. Now, special rule for treaties at D. Nothing shall be construed as permitting an exemption by reason of any treaty obligation of the United States from the provisions of this section. Now, if I could just pause here, this may require a little explanation, and we can find that explanation in the expert report of Mr. Miller, who was HMRC's expert. The experts produced a joint report saying they agreed with each other, and the Upper Tribunal has also found it useful to refer to the expert reports where necessary. So if I could ask you please just to briefly go to Supplementary 87. And that would be PDF page 834. And if I could ask you please just to read paragraphs 10 through to 12, including the example that's given. Now, we say that the provision, and in particular the example, is instructive for a couple of reasons. First, it shows that the US acknowledges, and this is our reading of it, that this deeming provision may not give the US taxing rights under the terms of a current or a future treaty. But the point that the guidance is emphasising is
Do we
that
have a date for that guidance?
I do not, but I can.
Yeah, I mean, it's a questionable. The guidance isn't. I'm sure you're going to make the point. The guidance itself isn't relevant to interpreting the treaty.
Exactly. It's not. But it's well. I think what I'd say about the guidance, as with all external aids to interpretation that aren't those listed in the Vienna Convention, they're as helpful as the.
Well, this is a one-sided. This is a one-sided view of a contracting state, which I thought was not something that should be taken into account.
But I think that this is the view of the contracting state as a matter of what its own domestic law is concerned with.
Yes,
As
I can see that. I mean, as I understand it, if I've understood this example, it essentially explains why, even if HMRC succeeds in this case, and even if the IRS were to agree with that result in terms of the treaty, the IRS would still say we can tax this income because domestic rules, 269B, override the treaty.
So put it another way, I'd say a couple of things. All this is an explanation, as we understand it, of what 269B1D
Yes,
is
but that's
saying.
it strikes me as a critical provision from the IRS's point of view. In other words,
Yes.
they'd say even if they agreed with the UK on the with your position on the interpretation of the treaty, that doesn't mean that
Exactly.
they give up taxing rights
Exactly.
because 269B tells them otherwise.
Yes, so taking it in stages, we certainly agree with your proposition that if the IRS had produced a memo that says we interpret Article 4.1 as meaning that stapled entities are resident, we put that to one side, irrelevant, because that's the IRS's view of the treaty. But we, well, a couple of points. It seems to us that from a matter of domestic law, domestic US law, that is actually what 269B1D is saying on its face. Since domestic US law is a matter of fact, we're relying on the evidence of the experts and the surrounding material as to what that factual point is. We're not relying on it in such a way as to interpret Article 4.1.
Yeah.
And what we see this as saying is exactly as my ladyship has just put it. Whatever the outcome under the treaty, you, entity, taxpayer, be warned that if you've chosen to put yourself in this position by way of stapling, we, the US, are not going to give you an exemption. Now, two things arise from that. That's all very interesting, as between the US and taxpayers, the US can do what it likes. What stapling can't do, and what that can't do, is say, therefore, UK, you have to cede your taxing rights, which is essentially the result and the effect of what my learned friend's argument is here. The second point that we make, and I think even GEFI acknowledged, they've acknowledged this in their skeleton all the way up, it looks like, on any view, they will get a credit from the US at the end of the day if HMRC are right in this litigation. And they complain about the fact that they're going to be out of pocket a bit on interest, but that's just because they didn't pay the tax they owed in the UK in time.
So there isn't, in reality, you say, a double tax problem here.
And
It's going to come out in the wash
exactly,
one way or another.
and that is something that's emerged from their skeleton argument, not because we say so. Yes.
But you say, can I just push that a bit further? Even if the US, let's say they were a state that wasn't prepared to give unilateral indulgences or whatever you want to call it, relaxations, you'd say that doesn't affect the. You'd hold the line and say that's still the treaty's the treaty.
Exactly.
And whatever they're doing domestically is an issue. The US taxing authorities and the
Exactly.
IRS.
Because we would say, because as we all know, Article 4.1 makes you treaty resident if you're subject to worldwide tax by reason of a local connecting factor. And if you don't have, and if stapling is not such a thing, you're not treaty resident, taxpayers, beware. Taxpayers, you know the treaty. Taxpayers, you know US law. You're no. Yes, exactly.
Thank you.
And the one thing, and I think this submission I accept does bleed into your ladyship's comment, but the one thing this is not saying is somehow we're not giving you the exemption, but under our treaty, this somehow forces you to go cap in hand to the other contracting state, because obviously the US through its own domestic law can't do that.
Sorry, I haven't got that.
So
Being slow.
the relevant provision is saying if you are stapled and you are liable to this tax, if it means you're subject to US tax and, in our case, UK tax, that's just too bad. The US can obviously do that vis-a-vis taxpayers because of sovereignty. What the US can't do through its own domestic legislation is essentially enforce on the UK a position where the UK has to now give up its taxing
understood.
rights because the US is saying, well, we're standing firm. Look at
We've
our
gone
taxing
first, we'll take
legislation.
ours.
Exactly.
Yes,
Now,
I understand that.
it all depends on what Article 4 means.
Yes, I understand that.
It's also a slightly interesting example because it's predicated on, in the example, the entity not actually being resident, treaty resident in the US, which is why the example is all concerned with whether or not it's got a USPE. Because you only care about whether or not an entity is doing a business through a US permanent establishment if it's not treaty resident. So that's a small point that we make on that. And I should show you this just so you've seen it. So this is going back to the authorities. The bundle we were in, tab we were behind 57. Page 1413 in the authorities. Just so you've also seen subsection E. In effect, it provides an exception from the tax treatment under 1A for companies that are ultimately foreign owned, and because we accept that GEFI is ultimately US owned, then 1E isn't in play in our case. So, pausing there, just to summarise the US position. In the US, domestic corporations are taxed on their worldwide income. A domestic corporation is one created or organised in the US or under the law of the US or a state. GEFI is not a domestic corporation, since we all agree it doesn't have those links. It's a foreign corporation, and so ordinarily it would be subject to US tax only to a limited extent. So ordinarily we wouldn't be having this debate at all, because everyone would agree that it's not within 4.1 from the US perspective. However, US legislation has this special rule in relation to what it calls stapled entities, where a non-domestic corporation shall be treated as a domestic corporation. So this is my ladyship's black is white deeming. Only for the purposes of Title 26 of the Inland Revenue Code, not for all purposes. So it doesn't suddenly have to assume whatever corporate governance requirements the US may impose on its domestic companies. You know, who knows what those rules may be. And the US legislation is clear. GEFI won't be entitled to any exemption by virtue of any double tax treaty. GEFI's on its own. So GEFI, in other words, by structuring itself this way, has assumed the risk that it could fall between two stones, two forts, whatever.
Just going back to one point you've just made about the provision being for the purposes of this title, one thing I've noticed comments on below and maybe in the skeletons is whether stapling is relevant for any other purpose other than the obvious legal point that the shares have to be transferred together. If we leave that to one side, there's been no suggestion. Is it actually, one thing maybe can be answered in due course as to whether it's common ground that there is no other implication of stapling?
So the answer from my individual perspective is I don't know what the position is. But as you have seen, you know, now we're in the Court of Appeal. If GEFI wanted to say, well, actually, there are all these other links to the US, the time for GEFI to do that was the first hearing.
Well, GEFI can respond on that in due course, but I just wanted to put the point.
But what, if I can put it this way, the one thing the parties didn't do was instruct US corporate law experts to actually answer that question.
Yeah.
So I can't tell you. For our part, we've assumed that if there were all these non-tax requirements and connections and so on, GEFI would have thrown evidence to suggest that was the case. So neither side have instructed a US corporate lawyer on that point. And that's the one point that we took issue with in the way the first tier had dealt with this. The first tier had said, well, we haven't proven the negative, to which we say, well, hang on a second. If GEFI had wanted to prove that as a matter of US non-tax law, stapling led to all these other connections and requirements and so on, it was GEFI.
Well, the burden was on GEFI in this case too.
Exactly. So we're entitled now to take the position that there's nothing more. So I think it's now convenient to move on to the double tax treaty, and you'll have seen from the timetable, I do intend to spend the bulk of my time on dealing on residents. I have probably very little at all to say about business, so we will be continuing with this well over lunch. So the UK double tax treaty is in Authorities tab 7, PDF 108, please. And so, pausing there, the matter at issue here concerns the taxation of interest income received by the LP on its loan receivables, and so we're interested in due course in income receipts because the LP is transparent by GEFI. So, if I could ask you to go to page 110, please. Article 1.1. The treaty applies to a person who's resident in one or more contracting states. And we're all agreed that on any view GEFI is UK resident. Scrolling down to the bottom of page 111, Article 1.8 deals with transparent entities. If I could ask you please just to move on over the page to PDF 112, and you'll see Article 2, sub 3B3, it applies to corporation tax. And then at the bottom of 112, you'll see Article 3 sets out definitions. And you'll see in the definitions section, there's no definition of domicile or resident or incorporation. If I could ask you please just to go to Article 3.2, which is near the bottom of PDF 115. Could I just ask you just to read Article 3.2 to yourselves briefly?
One of the questions I'm going to have in due course is when we get on to the subject of business.
Sorry.
On to the question of business,
Okay,
but
yes.
just to flag the question that's arisen in my mind is 3.2 is all very well where you're referring to a concept that's obviously relevantly used in domestic law, such as residence. This concept of business, as has been seen from the cases referred to, you really have to scrabble around for cases on the meaning of business, even in the context of the taxes to which the convention applies. And where you do find them, they're not used they're not relating to a use of the term business in a really relevant context, if I can put it that way. Because there's no test of whether you carry on business through a permanent establishment. The test is whether you carry on trade through a permanent establishment. So I have to say I struggle a bit with what both parties accept as I understand it, is the case, that you look at the domestic meaning where that meaning isn't really specific to the matter at hand. And the reason I ask the question is that if you just look at that domestic meaning of, say, business, in the context, for example, of capital gains tax, roll-over relief, or whatever Ramsey concerned, that is a meaning in quite a different context, and means that you might be interpreting a word that is used in a convention context in a different manner to the way you might interpret it in the absence of 3.2 applying.
Okay, so I think I take the point. Our response to that would be assume for the moment we're looking at business from the UK perspective.
Yes.
Then, for all the reasons below, etc., GEFI wasn't carrying on business and that can't be disturbed. We also know the meaning of business from the US perspective, led both the experts. So if you're looking at business through the eyes of a US
I'm equally
state
concerned
lawyer,
about the US angle
Certainly.
to this.
But
I'm more that 3.2 appears to slightly cut across what one might naturally do in interpreting a treaty, which is look at the word, the ordinary meaning of the word in its context and having regard to the purpose of the treaty. That's the tension I'm concerned about.
So if I could just I'll come on to that in literally 10
So
seconds.
I'm not necessarily asking you to answer it now because I know it relates to issue 2.
Yeah, and this may be, if I can just lay a marker, we know what the US says about business, and we've seen what their experts say if you're looking at the term from the perspective of a US lawyer. Our submission would be that for our purposes, in circumstances where GEFI isn't doing business either from a UK perspective or from a US perspective, it would be very surprising if the agreement between those two contracting partners somehow led to the word business meaning something broader in particular than the way that the concept is understood by either contracting state. And the final point on that, which I think it would be a point for, I think it's Mr. Binfield-Stockham who will be dealing with the submissions on this, and we can respond in due course. Certainly we are not aware of any broader international holistic treaty definition of business that gets GEFI over the line. So that's how we would approach the submission in front of you.
Thank you.
And in the event that they do identify for the first time such an argument, I'll respond to that in due course.
Thanks.
But given how this is supposed to be applied, it would be a very unusual state of affairs if business somehow was broader than either contracting state recognised business as being, I think, is where we would come down to that. And that would be a point about business as it is in the context of the treaty. Absent some pretty cogent reason as to why, for international treaty purposes, business should have its own specific treaty meaning. But just then, returning in relation to the question of residence, how we see this as applying in relation to resident, domicile, incorporation, etc. The UK, i.e. this court, is applying the convention at this time. Resident, domicile, etc. is not defined. And so those terms should have the meaning which at that time, under UK law, they are understood to mean in Article 4.1. So just to take a really obvious example in terms of how we would say we would look at Article 4.1, for individuals, we know the UK has a statutory residence test as well as the 183-day test. So the phrase liable to tax by reason of residence from a UK perspective would be met in relation to an individual if the UK statutory residence test is met, and a criterion of a similar nature will exist where the UK's contracting partner in any case has an equivalent test tying an individual to that country in a meaningful territorial way. There's no generalised treaty concept of individual or corporate residence, and so it doesn't matter that the US or other states may have different residence tests. And I'll come on to Fowler dealing with a separate issue of deeming provisions in due course.
Well, to be clear, I don't think you're saying, are you, that Article 3.2 applies to the phrase or any other criterion of a similar nature.
No, so just to be clear, if we can just move on then to Article 4.1, and I'll just explain it how we see it. So it's bottom of page 115. So the phrase, any person who under the laws of that state is liable to tax therein. So any person who's liable to US tax under the laws of the US, and then by reason of his domicile, residence, citizenship, etc., or any other criterion of a similar nature, how we see it is as follows. Domicile is the UK concept of domicile. What do we understand domicile to mean?
And that's because of Article 3.2.
Because of Article 3.2. Likewise, residence, so on. Now, the phrase, or any other criterion of a similar nature, we're not picking... I'm not coming to this court with words and phrases to cherry pick over what similar may mean or nature may mean, and showing you lots of UK cases about that.
So that's not a question of UK law, that's a question of treaty interpretation in accordance with the Vienna Convention.
Exactly, yes. And we'll see in due course that the Vienna Convention does pay respect to text, albeit not in an overly literalistic way, and it says that text must be interpreted in line to the object and purpose.
Now, that's a convenient juncture which to ask you this question. Do you say that the principle of construction that we recognise in domestic law, which goes by the Latin tag ejusdem generis, is either recognised by or consistent with the Vienna Convention?
So we would say, and certainly this comes through in some of the other texts, it seems to be a principle that is sufficiently recognised by other jurisdictions. So I think we'll see in due course the cousin text. He's not a UK author, but certainly it's a principle that's sufficiently widely recognised that it's not just something that is peculiar and unique to the UK.
Yes, what it might be said to be just a rational approach to the interpretation of words.
Yes. And that would be our submission on that. And put another way, what my learned friend hasn't pointed to is any source or authority or case that suggests that those words should be interpreted somehow differently. We just quibble over what the similar criterion is. That's in effect where the debate arises.
Yeah, well, if a principle equivalent to ejusdem generis is applicable, then obviously the next question is what is the genus of which these are species?
Exactly. And in order to answer that question, you have to look at the object and the purpose and so on and so forth. Yes.
Before we leave 3.2, can I just, I need to ask you this about 4.1 and as it's read with 3.2. Mm-hmm. So your submission just now was that when you're looking at 4.1 and you've got a person who under the laws of that state, and we postulate somebody who's you're looking at American taxation, so you're looking at US taxation, so the laws of the US, is liable to tax therein by reason of domicile, residence, citizenship, etc. And what I wrote down is that you say at that point you apply the UK concept of domicile, residence. Is that really right under 3.2?
Yeah.
That is,
so,
you switch
no,
it, because that's not what 3.2 says.
For the purposes of US tax.
So I have a couple of submissions on this. Pausing there, we say any person who under US laws is liable to tax therein.
In the US?
In the US, yes. Then you have by reason of his domicile, residence, etc. Now we say that since this is, we have to interpret this in the UK court from a UK perspective, we look at what is the UK concept of domicile, residence, incorporation, etc.
That's quite stretching under 3.2 because I would have
So we don't read it as a composite phrase, if I can put it like that. And I can see, because this is something we've thought about quite carefully, there are two ways of interpreting it. So problem number one, if in fact it's composite, there's no evidence at all before this court as to the American.
Sorry, I've got a helicopter outside.
I'll just pause, sorry. So assume for the moment it's composite.
Yeah.
There's no evidence at all before this court as to what the US sees domicile, residence, incorporation, so on and so forth, actually to mean. So how are we in the UK, especially you in the Court of Appeal, supposed to perform that exercise?
So no US evidence.
No.
The experts didn't cover the meaning of
They did not.
any of the words.
As it happens, and I want to come on to this in more detail when I talk about the UK treaties not having the word incorporation in them, which the Upper Tribunal placed weight on. As it happens, the US concept of domicile is different to our concept of domicile, because the US concept of domicile does require...
Sorry, how do we know that if there's no evidence?
Well...
You do.
So this is a point that I want, well, taking it in stages, that we say is one of the issues with the Upper Tribunal's reasoning based on other treaties with other countries, whether or not the UK has included incorporation. I think I'm all that I'm simply trying to say is, as it happens, the US concept of domicile is different to the UK concept of domicile. If we were seriously going to be having a discussion about what the meaning of those US terms meant from a US perspective, we would have needed US evidence on that. Mm-hmm. Given that we've got no US evidence on that, then simply as a matter of practice before this court.
But okay, I understand that practical point. Can we just look back at the interpretation of 3.2? Because I think you say, are you saying, just to make it, try and make this good on the language, never mind the absence of evidence, I'd rather think about the principle. We're looking at the application of the convention by the UK. I'm just looking at 3.2.
Yes.
And do you say that because we are looking at the application of the convention by the UK, we have to adopt the meaning under the law of that meaning state, meaning the UK? Yes.
And is that because we're concerned with UK corporation tax and seeking relief in respect of it?
Yes, but really the reason that concern arises, my lord, is because we're concerned with the application of this convention by a contracting state, i.e. by us sitting in the UK.
And by judges sitting
and by
in the
judges
UK.
Sitting in the UK, exactly.
That's all we know how to do.
And obviously in this context, it is because there is a corporation tax dispute, yes. If I can just make two more points, because I do appreciate that there are, looking at it literally, there are two ways of reading that sentence.
Well, I'm not sure I see the other way at the moment, but I'm probably missing something.
The second point that I would make is just as a matter of practice in this court, in the absence of foreign evidence, you would have to assume that those concepts are the same in the UK as they are in the US on any view. So that actually potentially resolves our issue on language.
I know, but I would much rather we were clear about what words.
And if I can make a third point, regardless of whether the US and the UK are the same, regardless of whether it's US or UK, when we get on, as I keep saying, to deeming provisions and Fowler, I would say we win anyway, regardless of which lens you approach this from. And in the event that Marlene and friends disagree on the language point, the pure interpretation point, then I'll come back again and deal with that and reply if that's acceptable. So it's instructive, bearing in mind that we are looking for the object and purpose, to also look at the other provisions of Article 4. And these are over the page. so page 115 of the bundle over to 116, as they give a flavour of the nature of the preferred criteria for treaty residence. So, Article 4.2, in the case of individuals, mere US citizenship or holding a green card isn't enough. There are other conditions requiring territorial connection to the US over and above a connection to any other place. Moving on to Article 4.3, in general terms, a resident of a contracting state specifically includes entities which have a connection to the state, even if they're not taxed because of specific exemptions owing to the nature of the entity. So pension fund is an obvious example. Pension fund may be exempt. Well, how if it's exempt, are you supposed to test that it's a resident of one state or another at all, because of the relevant connection? Article 4.4 introduces tiebreaker tests in the case of dual resident individuals, and all of these tests are based on the strength of a relevant local connection. Article 4.5 provides that in the case of dual residents who aren't individuals, competent authorities shall endeavour to determine how the convention should apply to the person by mutual agreement. And we're here, obviously, because we won't get anywhere with the mutual agreement procedure. Now, you only, in fact, get to a proper Article 4.5 determination where a person is resident of both contracting states. And so if HMRC is right, you actually don't have to get into Article 4.5 now at all. Article 4.6 requires a little explanation, but it is useful because it does go to the relevance of local connections. So if we can look briefly at Article 4.6, which is over the page on 117, and if I could just give you a couple of seconds just to read that, please. It's about marriage. This requires a little explanation, and if I can start off, the reason I'm bothered by this on a different subject matter is we'll see that the Supreme Court in Canada says that you should interpret the text according to object and purpose, but object and purpose is to come from the text itself, not from some overarching policy. And that, of course, is exactly how we would view purposive construction in the UK. You get your purpose from the rest of the surrounding words. So this is why I'd like to show you this and just explain it, please. So the common law position of the position of a woman married prior to 1st of January 1974 was that her domicile became that of her husband, and it was a domicile of dependence. That was the title. For marriages on or after, a woman's domicile would be unaffected by the marriage itself. Obviously, it would form part of the evidence to assess her domicile, either domicile of origin or domicile of choice, but domicile of dependence was no longer a relevant concept. Accordingly, what Article 4.6 is doing is it's operating by deeming that a woman who is a US national and who happened to get married to an Englishman before 1st January 1974 is not UK domiciled simply by virtue of her marriage, though obviously she still might have a UK domicile of choice depending on the circumstances. And this, we say, is quite an important indication, because if worldwide taxation is the only criteria that matters, why does the Convention concern itself at all with the nuances between different types of domicile and what the relevant domicile may be in a married woman's case? Now, it's also a fact that tax doesn't depend on domicile in the UK, but needless to say, the UK would have been free at any point, to change its tax system so that it did depend on domicile. And that provision is there in effect to say...
Well, this would be relevant for the remittance basis,
yes, and it would be relevant for the remittance basis.
So a US wife, even though living here, if she hadn't obtained a domicile of choice in the UK, she could still maintain the remittance basis.
Yes. But the point is, the tenor of all of these provisions is it's concerned with the relevance and the strength of the local connection. I would also add that if my learned friend is right, it's quite an odd thing to have Article 4.1 that simply says, all we care about is, are you subject to worldwide tax in a member state? And Article 4.2 onwards are going to delve straight into the minutiae of precisely why that is. We say that if my learned friend is right, you'd have expected some sort of intermediate stage. 1, are you subject to worldwide tax? 2, at a high level, why is that? Because we don't need to get into the minutiae if you're not actually similar to residence, domicile, or any of these other criteria. So it's just simply an extra point, is to say, it's an odd thing to say Article 4.1 is completely unbothered about relevant local connections. Now let's just delve into really granular local connections. Rather, the entire thread of relevant local connections runs through all of Article 4.1. Just so you've seen it, on PDF page 124 is the relevant provision in relation to interest. Article 11.1, interest arising in a contracting state and beneficially owned by a resident of the other contracting state shall be taxable only in that other state, and in our case that's in the UK. And you can see that Article 11.3 will operate to disapply Article 11.1 where the UK resident in fact carried on business in the US through a permanent establishment situated there, and the interest was attributable to that permanent establishment. Now, if I can just return to the wording of Article 4.1 itself, so that's back on page 1.1. I'd like to look on the second sentence, so that's page 116. This term, however, does not include any person, etc. So we say that that second sentence is, as it says on its face, concerned with excluding those who are liable to tax in a state only on a source or PE basis. And as we will see from the commentary, the second sentence is an odd sentence because it was specifically introduced by the OECD in its model convention just to deal with diplomats. But as you can see, it's not phrased expressly by reference to diplomats. How it is phrased is more generally, so is to exclude from treaty residents those who are only subject to tax in the source state. And we accept that the meaning of the phrase liable to tax in the first sentence of 4.1, because obviously it's one article, one paragraph, they should be read together, means, well, subject to full taxation. So if I can please move on to aids of interpretation now. The Vienna Convention is in the authorities bundle, tab 1, and the relevant page, please, is page 8. And there you'll see articles 31 and 32, which I think the court is probably familiar with.
Yeah, nobody's referred in the skeletons to Article 32. Do I take it that's because there aren't any relevant preparatory works, or at least none that are of assistance?
Yes, exactly, quite right. Quite right, my lord. And there are also no other agreements, instruments, practices, or any of the kind referred to in Article 31.
Well, beyond the later, beyond what you might glean from OECD
Yes.
material to which
Yes.
both contracting states are party.
I'm sorry.
To which both contracting
Yes.
states are party. So there is a point, isn't there, about subsequent OECD
There
material?
is, but certainly as we understand the Supreme Court in Fowler, again, the commentary is useful only to the extent of the cogency of its reasoning.
Yes.
So it's not to be read like statute.
Yes, but it's effectively permits a
Yes,
court
to look at it.
to look at it.
Exactly, yes. You'll have seen from the decisions that the US-Netherlands Treaty does have an example of what a relevant side agreement might look like. And if we can, and you'll see from my hand up that the US, no, you won't actually see from that, but the US-Netherlands Treaty is materially the same as the treaty we're concerned with. If I could ask you just to go briefly, please, to Authorities 3, tab 3, PDF 17 and 18. And in particular, over the page on 18, the subheading in reference to paragraph 4 of Article 4, resident, which actually seems to be a typo because it's concerned with paragraph 1 of Article 4, but, well, actually, no, sorry, ignore that last sentence. The way this operates is it in effect implicitly assumes that stapling leads to US residents. Now, for the purposes of that treaty, now self-evidently, that MOU, being part of the relevant context of the Vienna Convention, as far as the Vienna Convention is concerned, would obviously lead to an interpretation of that treaty, which is consistent with it. However, as the Upper Tribunal held, we say rightly at 122 to 123 of its decision, the existence of this is neutral for our purposes. So yes, it's worded to assume that a stapled entity would be treaty resident, but of course there's no way of knowing what other negotiations went on between the Netherlands and the US for them to get to that point, and for whatever reason the US and the UK chose not to agree a similar MOU. If I could please then go briefly to the various UK authorities, I just want to touch on 2, Irish Banks and Fowler. So Irish Banks is in authorities behind tab 40, PDF page 842, please. I'm just running through this very briefly. Paragraph 15 quotes from the Vienna Convention, Article 31. No, sorry, I'll just pause a second.
All right.
Tab 40. And paragraph 15 on 5. So that's the quote from Article 31. 16 over the page refers to Commerzbank, which in turn quotes from Fothergill, and this emphasises the importance of the words used, albeit cautioning not to use too literal approach. And if we go over the page, please, to little 5 and 6, that sets out that subsequent commentaries on a convention or treaty have persuasive value only depending on the cogency of their reasoning, which is the point I made a moment ago. And as we'll see from 18 to 23, the view or practice of one of the revenue authorities of a contracting party isn't an aid to interpretation. And then,
well, yes, you could apply that to the US-Netherlands side agreement, couldn't you? Insofar as you might say that that reflects a view of the United States. That's one contracting party.
Yes, I suppose you might, and both contracting parties might independently be of that view, but that in no way affects our position here. I mean, you know, but both in relation to the Netherlands MOU, both sides could make arguments as to why it in fact supports them. In our case, because of its absence. So at the end of the day, we're happy to just say it's neutral. It doesn't prove anything one way or another. And then, if I could ask you please just to go to tab 41 Fowler, which is PDF page for our purposes 1264. paragraph 16 through, oh no, sorry, I'm sorry, that's the wrong page. Sorry, if I could have 1 minute, please. So Fowler is tab 41, and I'm interested in paragraphs 16 through to 19, which is PDF page 870. And in particular at paragraph 18, which talks about the OECD commentaries and the weight to place on them. They're to be given such persuasive force as aids to interpretation as the cogency of their reasoning deserves. I mentioned that the Supreme Court of Canada had some words about interpretation as well, and the only reason for taking you to these is they reflect our own approach and our own understanding of purposive interpretation. So I think it's fair to say that it's reasonable that's a reasonable approach to a treaty too. So that's authorities PDF page, tab 44, page 986. And it's paragraph 58. And in particular, the last sentence, it must be remembered that the text also plays an important role in ascertaining the purpose of a provision. The proper approach is one that unifies the text, context, and purpose, not a purposive one in search of a vague policy objective disconnected from the text. And our main criticism of the Upper Tribunal and GEFI's argument is it does pay too little attention to the text itself. And it places too much weight on its reading of the OECD Model Convention commentary, which we say it approached a bit like reading a statute. It also placed too much weight on obiter in foreign cases, most significantly Crown Forest, which it treated as if it was some sort of binding UK authority. And it presumed, the Upper Tribunal presumed the intention of other different treaties that the UK had agreed in order to try and interpret this one. So, for example, it went off on a frolic of its own in relation to incorporation. It also made a rather peculiar sweeping statement at one point that neither side was able to give an example of where the parties, two contracting parties had agreed that a term that subjected one taxpayer to worldwide tax somehow wasn't also like residence or domicile, etc., which I just found a very bizarre thing to place any weight on, given that would require both parties to know exactly how every treaty in the world had ever been negotiated. And on any view, it really wouldn't be relevant to the outcome of this case. So I just want to make my submissions on text, object and purpose, if I may, before moving on to some of the other areas of interpretation. And our point is, on any view, those other areas are consistent with our argument. And the one thing you don't see in any of them is a clear statement that HMRC is wrong. Another seed that I'd like to say up front, one thing you don't see is any policy or purpose reason why HMRC should be wrong. What is so unreasonable that it somehow disrupts the fair operation of these treaties for requiring the existence of a local connecting factor for treaty residents? The Upper Tribunal, nor does my learned friend, neither of them have an answer to that. So starting off with the analysis of the words actually used, just for your note, you've seen it already, it's first tier tribunal, paragraphs 59 to 62. First tier agreed with our submissions that we say rightly for the reasons it gave. I just want to expand on some of our arguments, please. First of all, our interpretation gives meaning to the words by reason of his domicile, etc. On GEFI's interpretation, we say that you could put a line through those words entirely, and the article would mean exactly the same. Only those liable to taxation at source would be excluded from treaty residence by virtue of the second sentence. Secondly, if my learned friend was right and the only relevant criterion was liability to full taxation, then we would say the phrase criterion of a similar nature makes no sense. You'd expect wording like criterion of the same effect to be used. And I do say that this isn't going too far down some sort of linguistic rabbit hole. This is simply reading the words used and giving meaning and effect to those words. It's not being overly literalistic to do that. The criterion of full taxation is something that would be the same. It's not similar, it's the same. And moreover, that would be an effect and not the nature of domicile residence, or so on. I don't say, by the way, that any of these textual arguments on their own we win. I'm looking at them all as a whole. Now, the Upper Tribunal dealt with this, Upper Tribunal paragraph 81, just for your note, by essentially saying, oh well, but using the word similar nature would give greater flexibility to the phrase. But we would say, well, hold on a second, that's the reason why we should be right. If the only connecting factor is the existence of worldwide taxation, why do you need greater flexibility? You need greater flexibility if you're going to actually look at similar local connecting criteria, where each contracting state's domestic laws will be different in their peculiarities, but at the end of the day, they'll have broadly a consistent general thread running through in terms of the importance of different types of local connection, however their laws may be structured to recognise that. Thirdly, we say that if the only relevant criterion was full liability to tax, it would have been easy enough to say so. This is an international agreement, it's not UK primary legislation, and it would have been straightforward enough to find a form of words to that effect. There are indeed treaties that don't follow the OECD model and do use words a bit like that, and if I can ask you just to go please in the authorities. It's in one of the academic texts, but we've got no reason to think this is wrong. Authorities tab 49 please. PDF page 1221. And right at the bottom of 1221, you'll see that there is the penultimate sentence starts secondly, and the second sentence in that says the Canada-Australia Tax Convention provides that a person is a resident of a contracting state if that person is a resident of that state for the purposes of its tax. So there we don't care about criterion of a similar nature. Now, you might in our case have some fowler type argument about deeming provisions, but that is an example of a treaty where the different types of criterion just aren't relevant. You're not concerning yourself with that. Instead, the rule we are concerned with, and we'll see this in one of the texts later as Vogel puts it, is any locality-related attachment that attracts residence-type taxation. It's a two-stage test, and both stages need to be present. Now, thirdly, and on any view, and we'll see this when I look at the commentary in due course, even if it was deemed too difficult to draft that sort of formulation into the treaty, but all you need is worldwide tax is the intended effect. You would find that clearly in the commentary. It's such a basic proposition that you would expect the OECD Model Convention commentary to spell it out in terms. Instead, as we'll see, the commentary is concerned with the relevance of local links. Fourthly, as I've already shown you, the tiebreaker tests are all concerned with establishing the better quality of connection or closer link, and they go through disregarding matters that they perceive are not real links to the country. So the example of pre-1st of January 1974 deemed domicile of dependents. And I've already made the point that it would be quite strange indeed to have something that simply leaps from worldwide taxation straight into granular points of difference. Fifthly, if all that mattered was liability to full taxation and not the nature of the tie at all, then there'd be no need for the US-UK Convention to refer to the additional concepts of incorporation or citizenship at all. And we will see that the US in the Model Convention commentary specifically reserves the right to use a place of incorporation test for determining the residence of a corporation. And that would be irrelevant if all that mattered was whether or not the corporation in question was liable to full taxation. Now, the effect of my learned friends in the Upper Tribunal's analysis is in effect to say, well, those words, by reason of local connecting factors, are just there for the avoidance of doubt. But why would there be any doubt if the whole tenor and object and purpose was just purely your treaty resident if you're liable to worldwide taxation in the contracting state? The far better interpretation is one that gives meaning to the words, is one that gives meaning to the additions of the words incorporation and citizenship, for example. Now, pausing there, if I can put it this way, I will go on to show you that we in the UK tend to treat incorporation as being akin to corporate domicile. So it may be, from the UK's perspective, sitting in the UK court, that we see the word domicile in the OECD Model Convention, and we think, well, that incorporation is a criterion of a similar nature to that. If I can put it this way, so I'm not giving evidence, it might be, hypothetically, the case that the US might see domicile and place of management and residence all as requiring local connections of a different nature or strength. That might be why they saw fit to include incorporation and citizenship, because it mattered to them. Because they might not, interpreting Article 4.1 of the Model Convention through US eyes, they might say, well, actually, incorporation and citizenship are not similar to our understanding of residence, domicile, and place.
Can I just clarify one small point? I think you accept that domicile, the actual word domicile, should be interpreted in accordance with UK tax law, given we're sitting in this court, discussion earlier about Article 3.2. And in UK tax law, domicile is a term reserved for individuals. As opposed to wider private international law, which does use, turn up Dicey and Morris, does use the term domicile for corporate entities. Do you agree with that? Or because I think what you've just said is that the UK's position is to rely on the similar nature words to say place of incorporation is of a similar nature to domicile.
Yeah. So just taking it in stages, the Upper Tribunal's challenge to us is what do you make of the older treaties which don't include the word incorporation? The reply that I didn't have to hand then, but I do have to hand now, is to say that from the UK's perspective, the UK sees incorporation as being, in effect, corporate domicile. As I understand your ladyship's question, it was, well, that's all very well only from but that's only from a general law perspective. Tax law reserves the concept of domicile to individuals.
And we need to look at tax law for the purposes of Article 3.2. So
for the purposes of Article 3.2, tax law takes precedence that you can look at other law. And so what we would say is while, of course, you see the term domicile in our UK legislation in relation to individuals, there isn't in our tax law any provision that says, oh, by the way, domicile is completely meaningless in terms of companies. It just says nothing about companies and domicile because we know that our corporate tax turns on place of incorporation.
So just to make sure I've understood your submission, you're saying that Article 3.2, when it says has the meaning which it has under the law of that state, for the purposes of the taxes to which this convention applies, do you say then you do resort to non-tax law if to take this specific example, domicile isn't used
Yes.
in the corporation tax code?
And I think it is in the commentary, but I'll ask those behind me just to make sure that if it's not in the commentary, we definitely have the answer for this after the short adjournment. But I'm sure that there is a source that says as much. That if the tax law doesn't answer the question, you can look at general law.
Okay.
But if there's a clash between tax and general law, tax law takes precedence. If there's a clash between the same term in relation to two different types of taxes, use the definition of the tax with which you're concerned. So that's the waterfall in terms of priority.
It would be very helpful to see that.
I'll make sure that we find that source. It may be that we just see it for ourselves in the commentary when I get to it. So basically, if I can put it another way, and just pausing there, the flaw in the reasoning in terms of the Upper Tribunal's reasoning and approach to the language, it is essentially to try and justify why the words used can't mean what they say naturally by a series of excuses. Oh, well, it would be too difficult to draft a provision that just equated to treaty residence with only liability to full taxation. Oh, well, even though you don't require a local connection, these other terms in corporation citizenship are included just for the avoidance of doubt. Oh, well, we can't concern ourselves too much with the choice of words similar nature used because it's not a UK statute. Well, that all to us sounds like making excuses as to why you're going to depart without any good reason from the words that are actually written on the page. And our interpretation doesn't require any of those excuses. It simply says read the words on the page and interpret them as you would plain English. Now, then I move on to the point about incorporation, and the point that a lot of the UK's old treaties don't include the word incorporation. And the Upper Tribunal, certainly both at the hearing and you see slightly reflected in 97 and 99 of the Upper Tribunal's decision, sort of felt that this was a bit of a gotcha point. But with respect, old treaties, ancient treaties that haven't been updated are not a relevant aid to interpretation of this treaty, which is a more modern formulation. I mentioned that from a domestic perspective, the UK sees incorporation as being of a similar nature to domicile. And if, just say you've got it, the reference is to a 1940 case called GASC, which is Authorities tab 15. And if I could ask you just go to PDF page 309. And this concerned a company incorporated in Guernsey. And the last sentence on page 309 over to 310. And then also in the paragraph, it was suggested by Mr. Needham. The crux of this is, and then halfway down that paragraph in 310, but by analogy with a natural person, the attributes of residence, domicile and nationality can be given, and are, I think, given by the law of England to a body corporate. So too, I think such a company has a domicile if it's registered in England. So that's the penultimate sentence in that paragraph. And we've included, just for your note, because obviously that's a very old case.
This is a tax, but it is a tax case. Is it income tax?
Oh, actually, sorry. It is. I want to say
surtax.
That's a surtax. Yes, quite right. Yes. So, sorry. So actually, it's not a tax that's current today, but it is.
But it's a tax on income. It was a tax on income,
yes.
Although not obviously a tax listed in the treaty.
Yes. And just for your reference, this simply because it's an old case, you can see we've included in a bundle, it's PDF page 1439 in the authorities, tab 62. This is nothing more than a consultation from October 2021 on the government's proposals for corporate re-domiciliation, because I didn't want it said that, oh, but that's a 1940 case, today everything's different. It's still something that is accepted today in corporations.
Well, when you say accepted, you mean the terminology
Yes, the terminology and the
of
equivalence.
domicile.
Now, pausing there, let's say, for argument's sake, there is an old treaty out there, and if you want to pick a treaty, the UK's old treaty with Bangladesh, which doesn't include the word incorporation. Given that each contracting partner, or it could be any old treaty that doesn't include that word, it doesn't matter which one. Given that each contracting partner is presumed to know the other's laws, one may say, well, it's reasonably safe to assume that the UK, at the time that that treaty was entered into, understood that Bangladesh viewed incorporation as being akin to domicile in the same way. Who knows? Who knows? It doesn't matter one iota. And this goes back to our point, because whenever a UK court needs to interpret that treaty, a UK court will say, well, we're concerned with a UK incorporated company, we understand that to be a similar criterion to domicile, UK treaty resident, away we go. And if it so happens that a Bangladeshi court looking at that treaty does not form the same view, well, that's something that the UK should have understood at the time that it left incorporation out. And we don't know whether or not the US views incorporation like it does its concept of domicile. It may well not, as a matter of its US general or tax law. That may be why it felt that it needed to include incorporation in citizenship, because otherwise it would not have a local connecting factor of a similar nature. Now, moving on then, just to object and purpose, to step away from the pure language for the moment and come to the purpose of the words used. Certainly, so far as we see it, in GEFI's arguments and also in the Upper Tribunal's decision, neither have identified any reason why HMRC's interpretation is contrary to purpose somehow, or results in some sort of absurdity that we have to start casting around looking for some other interpretation that moves away from the text used. We say that the purpose of the residence provision is plainly to ascertain the quality of the connection between a person and a contracting state in order to determine who should have priority taxing rights, assuming, of course, that both contracting states impose worldwide taxation on that person. And if we're looking for rationale and why links may matter, if I could ask you please just to go very briefly to a paragraph in Alter Energy, which is Authorities tab 44. It's paragraph 74, PDF page 995. So tab 74, PDF 995, and then paragraph 74. And if I could ask the court just to read paragraph 74 to itself, please.
995, did you say?
Yes, I think, sorry if I misspoke. 995, paragraph 74.
Thank you very much.
So pausing there, that's setting out the rationale as to why some states should have more of a claim over certain types of income and others should have more of a claim over passive types of income. And we, of course, here are concerned with passive interest income, where the US is the source state. Now, just on a matter of rationale principle, what is said in alter, you would expect the resident state, i.e. the UK, to have the primary taxing right. There's no rational reason for that primary taxing right to be given up, merely because the US has decided to make GEFI liable to full taxation. In circumstances where, so far as we and the US are concerned, GEFI itself remains a foreign corporation. So if we're looking for some sort of purpose, that's the purpose. And we've explained this by reference to, in our skeleton argument, paragraphs 28 to 34, the blue logo example, which you'll have seen, and I don't intend to go through in detail. Now, my learned friend says, that's ridiculous, it's ridiculous. But we say, well, why? Because if the only rationale, if the only purpose of Article 4.1 is liability to worldwide taxation is all that matters before you're treaty resident, well, that gives power to contracting states to legislate how they want. And if it has an impact on the treaty, well, everyone's understood that from the outset, because everyone's understood that Article 4.1 doesn't require any relevant local connecting factor on my line of friend's interpretation. And so I don't think I need to repeat them, I don't think I need to expand on them, but I just adopt all the points and the arguments in particular that I made therein. Now, I'd like to move, if I may, on to domestic deeming provisions. And I think that this submission will potentially straddle interpretation and application, but I just want to deal with it all up front now. So it is a bit of a hybrid between the two. And my high-level submission, whatever I think I would say this court decides is the right interaction between Article 4.1 and Article 3.2, is Article 4.1 is concerned with the real state of affairs and not a deemed position for US tax purposes. So that's my very high-level submission. Put it another way, the mere fact that US tax law deems a stapled entity to be a domestic corporation does not mean that purely because of that deeming, it's automatically domiciled, resident, etc. What matters is the underlying relevant local connection. In addition to worldwide tax liability, obviously. And if I could ask you, please, just to look at Fowler, which is Authorities Bundle, tab 41, PDF page 864. And if I could ask you, please, just to read briefly the head note, which is page 864 and 865. Thank you. Now, pausing there, the position in Fowler is not exactly analogous, since there the question was, how is the UK to interpret and apply the treaty in view of a UK deeming provision? And of course, the question here is, how is the UK to interpret and apply the treaty in view of a US provision? But we say the principle of the black-white type deeming is equally applicable. And also, they apply with even more force, if you like, because our position is even further removed from Fowler. So just in a nutshell, in Fowler, the US tax legislation deemed someone who was...
You mean the UK tax?
Sorry, yes, UK tax legislation deemed someone who was in real life employed instead to be self-employed in particular circumstances for particular tax purposes. And as you'll have seen from the head note, nothing in the treaty required the articles to be applied to the fictional deemed world. And Article 3.2 didn't change matters. If I could just pick up on a couple of passages in the judgment itself, please. If I could ask you, please, just to go to PDF 867, paragraph 4. At the start of paragraph 4, you'll see the Supreme Court's observation in relation to the position in South Africa, we say is of direct relevance here. The deeming under US law is irrelevant for the purposes of determining whether a stapled entity has the relevant substantive connection. And then just skipping forward, please, to paragraph 25, page 873. Between little d and e, where the court says it's clear that it was not the purpose of the deeming provision in section 15.2 to resolve some legal or factual uncertainty about whether such divers were genuinely employed or self-employed. On the contrary, it applies only to employed divers. So that's the point I made earlier about different types of deeming provisions. Some that may be determining that dark grey should be treated as black, and then what we have here is the black versus white type deeming provision. And then 29 to 30 over the page, and the analysis section is actually quite short, and in due course, I'd be grateful if the court could just read it in due course, but we don't need to read it right now. 29 and 30, in effect, nothing in the treaty requires a deemed world to be taken into account. And then 31 asks the question whether section 15 of the domestic legislation in Fowler gives a different meaning to the relevant treaty terms. Answer no, and we say the same applies here. And indeed more than that, we say that actually section 269b specifically relies on GEFI's real life existence as a foreign corporation, because if you remember, the difference is, the condition is, do you have a domestic corporation and a foreign corporation which are stapled? So it is precisely because GEFI is a foreign corporation that you engage in the stapling rules in the first place. And 33 and 34 aren't relevant here. So pausing there, we say that actually the fact that for some purposes US tax law treats GEFI as a domestic corporation is of itself a red herring. What you're concerned with is the underlying factual real life situation when you're assessing whether or not there's a relevant local connection. Obviously the deeming is important because that is what it is that leads to worldwide taxation. But that tells you nothing about the quality of the connection itself. Just to put it another way, the difference between my learned friend and I is my learned friend says, I paraphrase, we're concerned only with the tax treatment as a matter of US law. I say, no, there's an additional criteria, which is the relevant local connection in the real world. If we're concerned with the real world, that the tax deeming is not relevant to that test. Next, so that was all I had to add to our skeleton argument in relation to object and purpose in addition to the text. I was now going to move on to the model convention and the commentary. And if I could start just by looking at the model convention so you've seen it, please. Authorities tab 5.
Now we're looking here at the 2000 version, presumably because that was just before the US-UK treaty was agreed.
There's one difference in the commentary. So we did do an exercise which was to compare the two to see if there was anything relevant in the later commentary. There's one point that I thought, I hesitate to even say if it's relevant, but I found it relevant enough to refer. So I'll show you that difference. If my learned friend wants to say there are other differences and it matters, I'll answer that to him. So page 74, you can see this is Article 3 now. We're looking at the OECD Model Convention. The equivalent of Article 3.2 is present in the OECD Model Convention. And then over the page 75, is the residence, the way that residence is defined. And if you look at our tracked version in our handout, you can see over the page, it's the second paragraph. You can see the relevant changes that get you from Model Convention Year 2000 to Article 4 that we're concerned with here. And the most obvious are the addition of citizenship in place of incorporation in our version, which is missing from the model. And you'll see that the second sentence has also been modified in our treaty compared to the model convention. I don't have a particular point I wanted to make on that. I just pointed out because what I suppose the only point I may say is it might be said that the second sentence of our Article 4.1 necessarily seems to be going beyond diplomats because it starts referring to profits attributable to a permanent establishment, which isn't a concept that you would associate with individuals and diplomats.
Can I get my bearings? What you're showing us here is the extent to which the model convention was altered or amended or negotiated to arrive at what we see as the Article 3 and Article 4 that we've looked at. Yes.
Exactly. So the tracking is what would you need to do to change the model convention into our Article 4.1. Mm-hmm. And so you can see citizenship in place of incorporation added. Exactly. And
the relevance of this, if I've understood it correctly, is that the model convention is the sole preparatory work that anybody's identified for the UK-US convention.
I would need to take instructions on that, but I think if your lordship means preparatory work such that it is relevant as a matter of Article 32 of the Vienna Convention, I need to take instructions on whether we'd accept that or not.
If it were otherwise, why would it be of any relevance at all?
This is quite an interesting point because the case law clearly tells us to look at the OECD model. Exactly. How you get there in terms of the Vienna Convention is perhaps not.
I think that's simply the point that I'm making. So we if I can put it this way, we accept that the relevant Article 4.1 in our case is based on the text of the model with relevant adaptations that have been specifically negotiated. We accept, therefore, that it would be helpful so far as the reasoning and the cogency of the reasoning suggests, as the Supreme Court said in Fowler, to see what is said in the OECD commentary. I think that Section 32 Vienna Convention would perhaps elevate the reliance or reference or weight you might put in the commentary to something more than we would accept.
Well, sorry, there's two different questions. At this stage, we're just looking at the OECD model convention itself.
Yes.
Which might be termed a secondary source.
Yes.
And the commentary might be termed tertiary source.
Yes.
And in the academics, possibly a quaternary source. That's another matter. But the question at this stage is, why is the OECD Convention relevant for the purposes of interpreting the US-UK treaty at all?
Yes.
And at the moment, I can't see any way you get it in under the Vienna Convention except Article 32.
So I will confirm this after lunch, but I don't think that it does come in under the Vienna Convention. In fact, can I just...
If it doesn't come in under the Vienna Convention, I want someone to tell me how it does come in.
Can I please just, if I'm saying something wrong, could I just have
Article
1 minute
32.
just to Sorry, I'm glad I checked rather than leaving it to lunch. So our position is that it does come under at least 32. There may be some argument for saying it's under Article 31. I apologise, I misunderstood.
Fine, well that makes sense, thank you.
So if I could please go to the discussion, and ask you to pick this up on the commentary, of the OECD Model Convention, Authorities tab 6, PDF page 99. So page 99 sets out the discussion in relation to Article 3.2, and you'll see at paragraph 13.1 that the commentary on Article 3.2 is essentially as we've just been discussing earlier. Yes, and actually, if I could ask you just to look at the second sentence, however, where in paragraph 13.1 of the commentary, however, where a term is defined differently for the purposes of the different laws of a contracting state, the meaning given to that term for the purposes of laws imposing taxes shall prevail over all others. And so that was the point about there being a hierarchy.
Thank you, that's very helpful. So, and the preceding sentence specifically refers to non-taxes.
Yes. And so, what I would say just generally, so page 100 over the page, is nothing you will see on the commentary in clear terms says all that matters for treaty residents is liability to worldwide taxation without any sort of local connecting factor. It just doesn't exist in this commentary. If I could briefly go through then some of the provisions, some of the paragraphs. And we've done this exercise in our skeleton argument as well, but if I can just make some points just orderly. You'll see, starting off with paragraph 2, Article 4.1 isn't concerned merely with resolving conflict between taxation according to residence versus taxation according to source. It's also concerned with resolving conflicts between two residences. So where in relation to both countries the relevant connection, local connection, gives rise to worldwide tax. So we say the connection is important too, not merely the notion of source taxation versus worldwide taxation. Moving on then to paragraph 3, generally the domestic laws of the various states, to paraphrase, impose full tax liability, and then this, based on the taxpayer's personal attachment to the state concerned. So that sets the tenor of the commentary. We're concerned with full tax liability as a result of the personal attachment. That's the reason why the commentary has in mind different types of personal attachment, as we'll see. Moving on to paragraph 4, and this is the paragraph which we say the Upper Tribunal, I suppose, placed too much weight on and misinterpreted. All that is being said in paragraph 4 is there's no treaty concept of domestic tax residence. There's no treaty definition of domicile, residence, place of management. So, for example, international law and the treaty will not tell you that you can only be treaty resident if you spend 183 days or more in a contracting state. But this does not say that a contracting state can treat a person as treaty resident by virtue of a test which bears no resemblance to what might internationally be recognised as residence. In other words, what paragraph 4 is saying is if it looks like what we all internationally understand the concept of residence to mean, so personal attachment, physical ties, the precise details as to whether or not you subject such an individual to domestic tax are up to you, the national state. So the contracting state. So we have the 183-day test, plus we also have a statutory residence test. All of that is designed to test physical connection with the UK. France may have something different. France may place its emphasis, I don't know if it does or not, so this is just hypothetical, on whether or not someone has a permanent home, whether or not someone's family is there. That doesn't look like our 183-day test. It's not identical to our statutory residence test, but both countries will understand those two different statutory tests as doing the same thing and testing the strength of the underlying connections in the same sort of way. And that's when I talk about conforming to some international understanding. Maybe norm is placing it too high, but some international understanding of residence. That's all to do fundamentally with these sorts of personal, in an individual sense, physical connections. And everyone understands that to be the case. And all that our paragraph 4 is saying is, we don't care precisely how you get there. It isn't saying we don't care about personal attachment at all, which is in effect what the Upper Tribunal interpreted it as. And so we say other criterion of a similar nature, that performs in effect two functions. It includes similar concepts that might be called something different to domicile, etc. So, for example, a company's main seat. It also acts as a valve to exclude concepts that are not that do not have that relevant local connection. And that, in turn, is in line with the object of Article 4, what it means to be treaty resident, which in turn is in line with the broader functioning of the treaty and the broader rationale which we saw from Alter Energy paragraph 74, different states should have different claims over different sorts of income and gains. We say that Article 5, when you read it objectively, makes it clear that Article 4.1 is concerned not only with liability to full taxation, but the reason for it. And it's precisely because different contracting states might have different domestic tests for residence that you then need some bilaterally agreed means of prioritising the strength of personal connections. And the example at 6 to 7 is itself, we say, supportive of Article 4.1 being concerned not only with full liability to tax, but also with the different types of connection. If I could ask you just to briefly read 6 and 7. So, the conflict that this article is set up to resolve is not just because the person concerned is fully liable to tax in both states, with no question as to why that may be so, but it's because he is liable by reason of differing person attachments between the 2 states. And that's the entire premise of the example. Why are we then getting on to the tiebreaker tests? It's because local attachments giving rise to worldwide taxation can operate in a number of different ways. That is not an example saying, take as your starting point an individual who is fully liable to tax in state A and state B. Now let's move on to ask where his main residence is. It's examining the reason why, because that is the only way you get through the gateway for treaty residence at Article 4.1, if you're liable to full taxation because of a relevant local connection. And that is why the relevant local connections in each case matter. You then have to go on to the tiebreakers. If we can go through now paragraph 8, so this is concerned with, in more detail, the provisions of Article 4.1. So paragraph 8, the second sentence, as far as individuals are concerned, the definition aims at covering the various forms of personal attachment to the state, etc. So we say it's clear from these words that mere liability to full tax is not enough. The article is concerned with various forms of personal attachment. And while I fully accept that the sentence begins as far as individuals are concerned, it's impossible to read into Article 4.1 itself a way to treat individuals and a different way to treat companies. The paragraph carries on. It also covers cases where a person is deemed according to the taxation laws of the state to be resident, and the example given is a UK diplomat. So a UK diplomat will be deemed to be UK resident whilst he's physically living in the embassy in another contracting state. But one can see that in such a circumstance there is still a strong link to the UK. The reason he's there is precisely because of government business. But that narrow sentence can't be interpreted as meaning that all deemed residents have to satisfy the connection test in Article 4.1, because I've already discussed there are different types of deeming. And the examples given are of the type of deeming where you can see that there is a personal link on any view, not a black and white, black versus white type example. Then the sentence beginning, in accordance with the provisions of the second sentence of paragraph 1, however, a person is not considered to be a resident of a contracting state if, although not domiciled, he's considered to be a resident according to domestic laws, but is subject only to source taxation. And there's an example again, diplomatic staff. So we say that the second sentence is intended to exclude those who might satisfy the connectivity test for residents, but it taxed only on a source basis. But that in no way proves, and I must say I still don't really understand the argument against us in this, that in no way proves that we are somehow wrong about no relevant local connection being required under the first sentence. Then the rest of that paragraph talks about inherent difficulties and limitations. So it gives an example of a corporate example, and it tells us that the second sentence of Article 4.1 has to be interpreted restrictively because it might otherwise exclude all residents of countries adopting a territorial principle in their taxation. So pausing there, the point being made by this sentence is that some countries, and just to give an example, Panama and Malaysia, only administer a territorial tax system. So what it looks like to be taxed as a resident in that country is you will be taxed on income arising in that country. But that is the extent of their own domestic rules. And what is being said here is you shouldn't interpret that article in such a way as to exclude all those countries that only have a territorial system of taxation. Now, I mentioned there was one difference with the later commentary, and so I'm simply going to flag it. If I could ask you, please, so that you've seen it, to go to Authorities tab 9 and PDF page 198.
Whose commentary is this?
So this is the OECD Model Convention commentary, but this is now the version for 2017.
Thank you very much.
And Melodship asked earlier whether there were differences in the later commentaries. Yeah. So just to be clear, there are other differences. Some are purely linguistic, some may have more...
There's differences in the tiebreaker, I've noticed.
Yes. But the only point that I wanted to point out is, and there's also differences in the numbering. So if I could ask you just to look briefly, page 199 of the bundle, 8.3. So we'll recognise that we've read words similar to this. The application in the second sentence, however, has inherent difficulties. Then it has to be interpreted in the light of its object and purpose, comma, which is to exclude persons who are not subjected to comprehensive taxation, brackets, full tax liability in the state. Note that is, in effect, the beginning and the end of what we say. The second sentence is therefore to exclude those not liable to full taxation. That's its correct interpretation, in effect. And so the fact that many years ago it may have been introduced to deal with specifically with individuals, the fact that you don't read the second sentence in order to read the words liable to tax as meaning full tax liability in the first sentence, all of that is absolutely fine, but that's essentially the meaning of that second sentence. And to start suggesting that meaning somehow excludes the requirement for some relevant local connection in the first sentence, we just don't understand the logic of that. We just don't understand how it works in that way. If I could return then, please, to PDF 102. So we're back in the commentary we've just spent our time looking at. Over to the next page, and now I'm looking at paragraphs 8.1 onwards. So this is still the discussion about paragraph 1, article 4.1. Opening words of paragraph 8.2. Paragraph 1 refers to persons who are liable to tax in a contracting state under its laws by reason of various criteria. So here again, the commentary is acknowledging the existence of those criteria. And in circumstances where we already know liable to tax so far as the OECD is concerned is liable to full tax, if my learned friend was right, you would have thought that here you'd have a full stop after persons who are liable to tax in a contracting state under its laws, full stop. But the OECD is concerned with the criteria. Moving on then, if I may, to paragraph 10, page 103. Now, this gets into the commentary in relation to paragraph 2 onwards, and this now starts looking at the tiebreaker tests. But it is useful just to look at a couple of places in this commentary because it reinforces the relevance of the personal attachment required in order to get through the gateway of Article 4.1 in the first place. So 10, to solve this conflict, special rules must be established which give the attachment to one state a preference over the attachment to the other state. And then, as far as possible, the preference criterion must be of such a nature that there can be no question but that the person concerned will satisfy it in one state only. And I do place weight on the words used here, criterion and nature, because that reflects criterion of a similar nature. That reflects the wording of Article 4.1. And you can see here the OECD commentary is using the word criterion and the word nature to talk about the relevant local connection, the real life local connection, not any simply tax dealing. And that is important, bearing in mind the drafters of the commentary are commenting on words that they have drafted in the OECD. It's not some sort of coincidence. Moving on then to paragraph, if I may, paragraph of the commentary, paragraph 21. So again, this is commentary on Article 4, paragraph 3, so we're still in the tiebreaker tests. Yet again, the tenor of 21 is it's making it clear the reason for taxation is important, subject to tax as a resident. Of course, it's possible if, for instance, one state attaches importance to the registration and the other state to the place of effective management. Again, here, the reason for taxation is relevant. And you see the word criterion again cropping up in preference criterion 23 and 24, again being used to discuss the real life relevant local connection, not some sort of tax result. And finally, moving forward to the reservations, you can see, if I can ask you just to look briefly at page 107, 31, Mexico and the United States reserve the right to use a place of incorporation test for determining the residence of the corporation, and failing that, to deny dual resident companies certain benefits under the connection, under the convention. And if it's also obvious that full taxation is all that was required, there's no need for Mexico and the United States to reserve their position in relation to incorporation. And I've already explained why they might want to do that, whereas systems with different domestic tax understandings of, say, domicile, may not feel they need to reserve their position. So those are my submissions on the commentary, and in short, no part of it clearly and expressly supports, we say, GEFI's interpretation. No part of it provides any sort of rationale why Article 4.1 shouldn't also include a real-life relevant local connection test. In fact, all of the pointers in the commentary emphasise the importance of the reason why full taxes is levied in the first place. If I may, that's all I wanted to say on the convention. If I see we do still have time, my submissions in relation to one of the foreign cases are very short, so we might conveniently do so before lunch if you're happy. So there are 4 foreign cases that I wanted to refer to. One of the Indian Appellate Tribunal, then there's the Portuguese Supreme Court, Crown Forest and Alta Energy. And if I can simply go to the Indian case first, and I appreciate that, we're not relying on this for the status of the court, but simply the cogency of the reasoning and the application. So this is Authorities tab 27, PDF 519, please. And the facts themselves don't matter, since the passage we rely on is very self-contained. It's also quite compressed. But if I can explain what I think is going on here, it concerns, so paragraphs 3 and 4. Indian capital gains tax on the sale of shares in Indian companies to a Dutch company. India had a rule that Indian CGT arose on the sale of capital assets situated in India. Hence, in this scenario, Indian CGT arose, and that's paragraph 12. The taxpayer tried to argue, amongst other reasons, that the group was treaty resident in the Netherlands under the DTA, the India-Netherlands DTA, and as such, the transaction was taxable only in the Netherlands, not India. And the argument, in effect, failed. And you'll have noted that it's General Electric, but that's obviously
I think
just
it's a different company.
Different company.
It's, yeah, right.
Different company.
Yes,
Okay.
it's
So
different. This is
a,
the UK GEC.
oh yes, yes,
Yeah,
but
hence,
it's
hence the famous trademark case.
pure coincidence. I have nothing more to offer on that. So, what we will see is what I think is quite a useful shorthand. Vogel is referred to in this decision. The term should be understood to mean any locality-related attachment that attracts a residence type.
Sorry, where are you reading from now?
Taxation. I was just about to ask you to go to page 523.
Yep.
And read paragraphs 13 through to 16, and you'll see that quote appear in 16. And the only other observation I want to make is you'll have noted earlier in 16, when you get to it, that India considers incorporation to be equivalent to domicile as well. So 13 through to 16, which is self-explanatory.
Aha, they bring in a Eustem generous. Yes, I hadn't appreciated that, but yeah. Yeah, and they make the point that the very language of the treaty itself is an Eustem generous provision. Yeah.
Yes, I thought I'd remembered that coming up in one of the other cases, but I didn't want to promise that it had in a foreign courts context as well. And so the phrase that I read out earlier, the term should be understood to mean any locally related attachment that attracts residence type taxation, is the quote from Vogel, which we say very neatly encapsulates our two-stage test. And I think those passages speak for themselves. So if now's a convenient moment, I'm happy to resume after lunch, and we're nearly there.
Very good. We'll resume at 2 o'clock.
Thank you very much.
All right.